seen in the history of this committee. Judge Kavanaugh, that reflects on your reputation and your credibility. If you said at this moment, I don't want to have a cloud over this nomination, I'm prepared to suggest to the committee and ask the committee humbly, please withhold further hearings until you disclose everything. Why won't you do that?
Senator, I do not believe that's consistent with what prior nominees have done who've been in this circumstance. It's a decision for the Senate and the executive branch. Justice Scalia explained that very clearly, I thought, in his hearing.
Are you happy with that decision?
I do not. It's not for me to say, Senator. This is a decision, the long-term interests of the Senate and the executive branch, particularly the executive branch, are at play. And Justice Scalia, again, explained that well, I thought, in his
I wasn't
hearing.
here for Justice Scalia, but I will tell you that...
Let me interrupt without taking time away from you, so don't charge him for this time, but here's something that the nominee doesn't need any help for me to answer this, but we don't care what the nominee thinks. Well, we've got to follow the Presidential Records Act, and that's what we're following as a law.
Mr. Chairman, with all due respect, following the Presidential Records Act involves the National Archives. The National Archives is not involved in this process. It is a Mr. Bill Burke, who was a former assistant to the nominee, who has decided what will be withheld, what is going to be committee confidential. So it isn't the Presidential Records Act, please.
Well, let me make clear here. We anticipate some of this, so let me read. Criticize the committee process for obtaining Judge Kavanaugh's records. They have accused us of cutting the National Archives out of the process. So this is where I want to set the record straight. President Bush acted consistently with federal law when he expedited the process and gave us unprecedented access in record time to Judge Kavanaugh's record. But we have worked hand in glove with the archives throughout this process, and the documents this committee received are the same as if the archives had done the initial review. In fact, the archives is not permitted by law to produce records to the committee without giving both President Bush and a current president an opportunity to review. The National Archives was not cut out of the process. As President Bush's representative informed the committee, quote from his letter, because we have sought, received, and followed NARA's, that's the same as what I use the word archivist, views on any documents withheld as personal documents, the resulting production of documents to the committee is essentially the same as if NARA had conducted its review first and then sought our views and the current administration views as required by law. In other words, the documents this committee received are the same as if the archives had done the initial review. We're just able to get the documents faster by doing it this way, which gave the Senate and the American people unprecedented access in record time to a Supreme Court nominee record. Continue.
Mr. Chairman, the National Archives have stated publicly that the way we are handling the records for this nomination are unprecedented, and they've had nothing to do with it. They have asked until the end of October to produce records, and they've been told, we don't need you. We're going to finish this hearing long before then. I'd like to ask that be placed in the record the statement from the National Archives related to the records related to Judge Kavanaugh. I have consent to place this in the record?
Yes. I'm sorry.
Statement from the National Archives.
Put in the record, yes, without objection.
Thank you. And now I'm going to throw you a pitch which you've seen coming for 12 years. I want to talk to you about the 2006 testimony which you gave before this committee. It was at a different time. We were very concerned about the issue of torture and detention and interrogation. Yesterday I asked you to show the American people that you have nothing to hide by coming clean with us on this issue. And I'd like to refer specifically to some of the questions that were raised because of that 2006 testimony. I believe we have here a statement of my question as well as your response. I'm sure you've seen this because it's been reported in the paper that you've been waiting for this question for a long time. When I was back in the day a trial attorney preparing a witness for interrogation, testimony, deposition, giving testimony at trial, I said two things: tell the truth and don't answer more than you're asked. Don't volunteer information. Judge Kavanaugh, you failed on the second count. The question I asked you, what was your role in the original Haynes nomination decision to renominate him? And at the time of the nomination, what did you know about Mr. Haynes' role in crafting the administration's detention interrogation policies? Your response, Senator, I did not. I was not involved and am not involved in the questions about the rules governing detention of combatants and so I do not have the involvement with that. And with respect to Mr. Haynes' nomination, I've known Jim Haynes, but it was not one of the nominations that I handled.
You raise it a little higher. I can't see the bottom. I got it.
Good.
Okay. Yes.
I asked you about this when we had a meeting in my office.
Yes.
And I still don't understand your answer in terms of how you could state as clearly and unequivocally, I was not involved and am not involved in the questions about the rules governing detention of combatants.
Yeah.
You were involved in the discussions about access to counsel for detainees. You confirmed this during the meeting we had in my office, and there are multiple media reports as well. You were involved in discussions regarding detained U.S. combatants Yasser Hamdi and Jose Padilla. You confirmed that in our meetings, and there are emails that support that fact. You were involved, and this is one I want to be specific about, you were involved with President Bush's 2005 signing statement on Senator John McCain's amendment banning cruel, inhuman, and degrading treatment of detainees, and you confirmed that in the meeting. There were no exceptions in your answer given to me in 2006, not for litigation or detainee access to counsel or the McCain torture amendment. So if those three, based on the limited documents which we've been given, are obvious, what were you trying to tell me here? Did you really disclose accurately your role?
Yes, I understood the question then and my answer then, and I understood Stan.
People have human rights. We're allowed to make our own medical decisions.
Go ahead.
I understood the question then and the answer then, and I understand the question now and the answer now to be 100% accurate. You were concerned about whether I was involved in the program that two other nominees had been involved in, and the report that Senator Feinstein produced, the Justice Department report, they showed that I wasn't. In other words, the program, crafting the program for the enhanced interrogation techniques for the detainees.
Judge Kavanaugh, that's not the question. Do you see me asking you whether you crafted the program? I didn't. I asked you about your involvement in the Haynes judgment, and then you went further.
Crafting.
Yes. Then you went further. You violated the second rule I gave to every witness. You answered more than I asked.
I adhered to the first one. I told the truth.
Well, you volunteered more information than I asked, and you went further than you should have. Because in the three specific instances I've given you, you clearly were involved in questions about rules governing detention of combatants.
So I understood the question then, and I understand it now in my answer about that, that program. I told the truth about that. And the reports that have come out subsequently have shown that I told the truth about that. My name is not in those reports. Now, for the 2005 signing statement, by that time I'm in staff secretary office, and everything that went to the president's desk, with a few covert exceptions, would have somehow crossed my desk on the way. So you asked, I said on a signing statement, it would have crossed my desk on the way. So would a speech draft on the Iraq War. So would a speech, those things would have crossed my desk, prepared by others, not prepared by me, but they crossed my desk on the way to the president.
In the 2006 hearing, you told Chairman Arlen Specter you gave President Bush advice on signing statements, including, quote, identifying potential constitutional issues in legislation. Did you make any comments regarding the December 30th, 2005 signing statement on the McCain torture amendment, including potential constitutional issues?
I can't recall what I said. I do recall that there was a good deal of internal debate about that signing statement, as you can imagine, there would be. I remember that it was controversial internally. And I remember that I thought, and I can't remember all the ins and outs of who thought what, but I do remember that the counsel to the president was in charge ultimately of signing statements in terms of the final recommendation to the president.
And just a few months later, you, under oath, told us you were not involved in any of the questions about the rules governing detention of combatants.
Senator, again, we were, at least I understood it then, and I understand it now to be referring to the program we were talking about that was very controversial, that Senator Feinstein spent years trying to dig into. And I was not read into that program. I told the truth about that. And
let me go to another area of questioning if I can. Thank you very much. In your dissent in Garza versus Hargan, you wrote that the court had created, quote, a new right for unlawful immigrant minors in the United States government, detention, to obtain immediate abortion on demand, thereby barring any government efforts to expeditiously transfer the minors to their immigration sponsors before they make that momentous life decision. You argued that permitting the government additional time to find a sponsor for a young woman in the case did not impose an undue burden, even though the government's conduct in the case had already forced her to delay her decision on an abortion by several weeks. We are talking about a young woman.
Hi, everyone. I want to recap here. I'm Rena Ninen in New York. You've been watching Brett Kavanaugh's confirmation hearing on Capitol Hill. We're going to bring you back to this in just a moment, but we want to sort of give you a sense and bring you up to speed on what's really happened so far with this hearing. This morning, we know Kavanaugh was questioned about his views on Roe v. Wade. That's, of course, the 1973 Supreme Court decision legalizing access to abortion. Kavanaugh has stated that his views on this ruling he would consider as settled law, and he explained this and his thoughts on that earlier today.
I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years, as you know. And this is the point I want to make that I think is important. Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. It's not as if it's just a run-of-the-mill case that was decided and never been reconsidered, but Casey specifically reconsidered it, applied the stare decisis factors, and decided to reaffirm it. That makes Casey a precedent on precedent.
And Mola Lenghi joins us now from Capitol Hill with more on today's hearing. So, Mola, you heard that soundbite there with Kavanaugh repeating that Roe v. Wade is settled law. Is that enough to provide comfort to people who are concerned that abortion rights could be overturned in the Supreme Court?
Well, Rena, probably not, just because Kavanaugh never really took a position. You know, he talked sort of in generalities about precedents, about settled law, but as we heard, and there was more to that than that soundbite, but really saying the same thing over and over again and never really answering Senator Feinstein's question and answering exactly where he stands on the issue. It was Senator Feinstein who really probed him about Roe versus Wade, and Kavanaugh's response again was it's settled law. It is the precedent has already been determined, and you know, even when he was asked by Senator Feinstein, you know, well, what is your view of settled law? Is that something that can be, you know, overturned or you know, can it be overturned or anything like that? And he didn't really want to go down that road. Just again saying that this is something that has been tested and stood for decades, 45 years, and it is settled law. But he said all that without ever really giving his position on Roe v. Wade or even on the women's right to choose.
You know, Mola, when we're watching these hearings, you always look for these off-the-cuff moments, and there was a moment yesterday, a bit of controversy, when the father of a girl who was killed in the Parkland shooting accused the judge of turning his back on him when he actually tried to reach out and shake his hand. We've got this moment right here with the father from Parkland. How did Kavanaugh respond, and has there been anything from his team on this?
Nothing publicly, you know, and Senator Lindsey Graham, who's on the Judiciary Committee, is the one senator who sort of brought it up, in a broader question. Senator Lindsey Graham asking Judge Kavanaugh, sort of what he feels, what his view is on people who have been victimized and the people who are less fortunate and needy. And, in that questioning, he brought up the Parkland father. He brought him up by name and sort of asked, what is your view of these sort of things? What's your approach? What is your, your sort of your life approach to the needy and to the less fortunate, to the less among us? Now, while Senator Graham referenced the Parkland father by name, in Judge Kavanaugh's response, he never really went there. He didn't take the bait. He didn't. Not that it was bait from Senator Graham. It was sort of a softball question for him. But he never went there. He talked more generally about his volunteer work with the homeless and through Catholic charities, and his general view that all people are equal regardless of their lot in life, and that he's no better than a homeless person on the street. So sort of talking about it generally, but not talking specifically about the Parkland father, who obviously is making a lot of headlines today.
And Mullah, in light of the Mueller investigation, everyone's curious what Kavanaugh has to say about presidential powers. I want to play a bite for you about this.
President Trump claims he has an absolute right to pardon himself, does he?
The question of self-pardons is something I have never analyzed. It's a question that I have not written about. It's a question, therefore, that's a hypothetical question that I can't begin to answer in this context as a sitting judge and as a nominee to the Supreme Court.
On the other hand, does the president have the ability to pardon somebody in exchange for a promise from that person they wouldn't testify against him?
Sarah, I'm not going to answer hypothetical questions of that sort. And
Do the Democrats have traction on this issue of presidential powers, and did we get an insight into Kavanaugh's view on that?
Well, we didn't get any insight. He as you really heard him say, and that's something that he, again, one of those responses that he didn't really expand on much, but we heard a lot of that sort of response, and that was that he didn't want to answer hypotheticals, that he wasn't going to go down that road. And from Senator Leahy, again, from him, he certainly didn't take the bait, sort of dismissing it as a hypothetical, and that judges, shouldn't go down that road. This is the Democrats' issue. This is their big concern about Judge Kavanaugh. Yes, they have other issues like Roe v. Wade and health care and how he may come down on those issues, but their main issue, the thing that is probably prompting this stalling strategy, this sort of stalling tactics that we've seen over the last few days, is how Judge Kavanaugh and how a Supreme Court Justice Kavanaugh may rule on presidential pardons, on all of the sort of legal issues that are clouding over the White House right now, whether President Trump ultimately decides to fire Special Counsel Robert Mueller, whether a sitting president can be indicted. These are all the issues that the Democrats are really concerned about, and their fear is that a president who may down the road be indicted is handpicking the Supreme Court justice who may ultimately decide that president's fate. And so Judge Kavanaugh didn't really take a position where he stands on the issue. And so Democrats still very concerned, but ultimately, Rena, there's really nothing they can do at this point. They do not have the votes to block this appointment. And so stalling and sort of shedding light on the issue is really all they can do at this point.
Mola Lenghi coming to us from Capitol Hill outside the Kavanaugh hearings. Thank you very much, Mola. We do want to take you back to the confirmation hearing of Judge Brett Kavanaugh. Let's listen in.
Lawn cut, call me. So lawn cutting and then the construction job, the one summer.
My dirtiest job I ever had was 4 summers working in a slaughterhouse.
Yes.
I always wanted to go back to college.
Yes.
I couldn't wait to get out of there. It was unbearable. It was dirty. It was hot. Things I did were unimaginable, and I wouldn't even start to repeat them. Then came a case before you called Agri-Processor Company versus NLRB. At least a third of the workers, Judge Kavanaugh, in our nation's slaughterhouses are immigrants. It stands visits to Iowa or Illinois, probably Delaware, you pick it. You're going to find a lot of immigrants doing these miserable, dirty, stinking, hot jobs. Many of them are undocumented. The work is low-paid and dangerous. And as the GAO has noted, immigrants are pressured not to even report injuries on the job. Agri-Processors case was a notorious meatpacking company owned by Shalom Rabashkin, who was convicted of 86 counts of fraud and money laundering in 2009. His 27-year sentence recently was commuted by President Trump. Agri-Processors had at the core of its business model the exploitation of undocumented workers. Half their workers, almost 400 of them, were not authorized. Workers alleged the company fostered a hostile workplace environment that included 12-hour shifts without overtime pay, exposure to dangerous chemicals, sexual harassment, and child labor. A truck driver at Agri-Processors' Brooklyn warehouse told reporters, quote, "We were treated like garbage, and if we said anything, we got fired immediately." Judge Kavanaugh, you bent over backwards to take the company's side against these workers. In a 2008 D.C. Circuit case, Agri-Processor versus NLRB, your dissent argued that this company's workers should be prohibited from unionizing because they did not fit your definition of an employee. To reach this conclusion, you imported a definition of employee from a totally different statute. You ignored the plain language of the controlling statute, the National Labor Relations Act, which has a broad definition of employee, as well as binding Supreme Court precedent. The majority in this case, and you were a dissenter, the majority in this case noted that their opinion stuck to the text of the National Labor Relations Act and to the 1986 Immigration Reform and Control Act, which did not amend the National Labor Relations Act. They said that your dissent, these other judges said about your dissent, would, quote, abandon the text of the controlling statute and lead to a, quote, absurd result. The majority in this decision included one Republican and one Democratic appointed judge. Judge Kavanaugh, you claim over and over again to be a textualist, to be carefully weighing every word of a statute.
Yes.
So why did you go out of your way to interpret the word employee in a way that benefited this horrible business and disadvantaged these exploited workers? Why didn't you stick to the plain language of the controlling statute and the binding Supreme Court precedent?
Because the Supreme Court precedent compelled me to reach the result that I reached. And here's why, Senator. Let me explain. The Supreme Court had a case in 1984 called the Shurtan decision. And the Shurtan decision considered the interaction of the National Labor Relations Law Act and the immigration laws. And what the Supreme Court did in Shurtan is had this question and said it is at that time permissible to consider an immigrant unlawfully in the country as an employee under the National Labor Relations Act. And in Part 2B of the opinion, you have to read Part 2B of the opinion, of the Supreme Court's opinion. If you read Part 2B of the opinion, the court then goes on to say, and because the immigration laws do not prohibit employment of people unlawfully in the country, and makes clear, the Supreme Court makes clear, this is when it's being considered in Congress in 84, it ends up in the 86 Act. The court makes clear, as I read Part 2B, and I think I'm correct on this, that if the immigration laws did prohibit employment of someone here unlawfully in the country, then that would also mean that they can't vote in the union election. So what I was doing there, Senator, it's all about precedent. I read that, and my opinion, if you look at the dissenting opinion, I really parsed this very carefully, and I went deep into this case. So I went back and pulled from the Shurtan case, I went and asked for the Marshall papers, Thurgood Marshall papers from the library to read all the memos that went back and forth among the justices in the Shurtan case. I cited the oral argument to make sure that what I was reading in there was actually reflected what had been going on in the Supreme Court. And it is quite clear from the oral argument, they were aware that the immigration law was about to be changed, and they were aware of the interaction between the labor law and the immigration law. So I think I stand by what I wrote then, and I think I correctly analyzed Part 2B. Now, Senator,
I have to.
If it ends
out of time here.
I know, but if it ends, if the Supreme Court's Shurtan opinion had ended at Part 2A, 100% would agree with you, and my decision would have been different.
Well, let me just
if
say
you read
this.
Part
You said
2B,
to-
I think you see.
You said earlier today you don't get to pick and choose which Supreme Court precedent you follow. The majority in agri-processor's case was following Supreme Court precedent. In the Shurtan case, the Supreme Court, a 7-2 decision, said that undocumented immigrants are employees under the National Labor Relations Act. I quote, "Since undocumented aliens are not among the few groups of workers expressly exempted by Congress, they plainly come within the broad statutory definition of employee." That's a quote from the case.
But that's Part 2A. You got to go to Part 2B.
Well, let me hang on. Let me tell you some people who went to both parts and couldn't disagree with you more. Everyone else who looked at this question, the administrative law judge, the National Labor Relations Board, including Republican appointees, 2 appeals court judges, including 1 Republican appointee, followed the Supreme Court precedent and came to the opposite conclusion that you did. I understand you may have preferred the Shurtan dissent, but you failed to follow Supreme Court precedent. This was a case where the National Labor Relations Act included those who were undocumented who could unionize to protect themselves in the workplace. You went out of your way to dissent all the way along and make sure they didn't, or in your view, not have that right, that they did not have that right to unionize.
I very respectfully disagree, Senator. And the reason I disagree is that the Supreme Court did say that the immigrant was covered under the definition of NLRA. If it ends there, I'm with you 100%. But then the Supreme Court goes on to say, and we consider also in resolving this question the conflict between the National Labor Relations Act and the immigration laws, and makes clear, as I read it, if the immigration laws had made employment of someone here in the country unlawfully illegal, then that would be prohibited in the case. And I went back, like I said, if you look at Justice, I quote the oral argument transcript from Shurtan in my dissenting opinion. I have no agenda in any direction on I'm a judge, so I'm just trying to resolve the precedent.
Well, let me close by saying this. I'm just a judge. I just follow precedent. Gosh, we've heard that so often, and I hope it's the case, but we know that there's much more to your job than that.
I agree.
The fact that you were a dissenter and everyone else saw this the other way should give us pause when you say, I'm just following precedent.
Well, I respectfully, Senator, that opinion, I'm proud of that opinion because I think it carefully details the law in that case. I'm following the Supreme Court precedent. And to your point that other judges disagree, there was a case I had about 10 years ago or 8 years ago called Papano. It was a case where I ruled in favor of a criminal defendant on a restitution matter. Every other court beforehand disagreed. I wrote the majority opinion with Judge Edwards and Judge Griffith. Every other court after us disagreed. Finally got to the Supreme Court this year in the Lagos case, and they agreed with our one opinion, the Papano opinion. Just to point out that just because other courts of appeals might have disagreed does not necessarily mean we were necessarily wrong, because the Supreme Court ultimately decides that. I understand your question. I appreciate them. Thank you.
Senator Cornyn, and Senator Lee's going to chair while I have another appointment. Senator.
Thank you, Mr. Chairman. Mr. Chairman, I was grateful that today's hearing, at least as far as the committee is concerned, is a lot more dignified and civil. But unfortunately, some of the hijinks continue even on the Senate floor. I know Senator McConnell asked consent for the Judiciary Committee to continue meeting during today's session of the Senate. Senator Schumer objected, so Senator McConnell was left with no option but to adjourn the Senate and allow the committee to continue to meet. That's unfortunate. So, Judge, I believe we met in the year 2000.
Yes.
And just to take a little walk down memory lane here, when I was Attorney General of Texas and had a chance to argue a case in front of the Supreme Court of the United States, you, Ted Olson, and Paul Clement, I believe,
yes,
helped me get ready. I regret you didn't have better material to work with. But
It was an honor, Senator.
Well, it was a great experience and an educational experience, but I got to appreciate your skills as a lawyer from that time and have followed your career closely since. And I'm proud to support your nomination based on my personal knowledge of your skills, your temperament, and your character, and your fidelity to the rule of law. But I do want to pick one bone with you. I did this. This isn't unique to you. Based on that experience, that case, as you may recall, involved a tradition in the Santa Fe Independent School District, unfortunately, which was the site of a shooting here in more recent days. But back then, the practice before football games was that the students would be able to volunteer to offer a prayer before the football game. They weren't required to do so. The school didn't pick them. They could offer an inspirational saying or read a poem or anything else. But that was the practice. Well, until the ACLU filed suit, and unfortunately it was held to be unconstitutional in violation of the Establishment Clause. I'm not going to ask for your opinions because this issue will likely come back before the court, but since I mentioned it to Justice Gorsuch, I'm going to mention it to you. The thing that is stuck in my craw for the last 18 years is the dissent written by Chief Justice Rehnquist, which takes exception to the majority's decision, saying they distorted existing precedent. But he goes on to say, even more disturbing than its holding is the tone of the court's opinion. It bristles with hostility to all things religious in public life. Neither the holding nor the tone or the opinion is faithful to the meaning of the Establishment Clause. When it is recalled that George Washington himself, at the request of the very Congress which passed the Bill of Rights, proclaimed a day of public thanksgiving and prayer to be observed by acknowledging with grateful hearts the many and signal favors of the Almighty God. Since I had you here, I thought I'd mention that.
Yes.
I'm not asking for your opinion, since likely you'll be called upon to decide cases involving the Establishment Clause in the future. But since we had that history together, I thought I would just tell you that still sticks in my craw.
I understand, Senator. We remember certainly cases I lost. I remember, and they still stick in my craw too, Senator. So.
Well, I just marvel that under the First Amendment that we can, a variety of voices can speak, and that's generally a good thing, but it can be about violence, sexism. It can be about almost anything, but you can't speak about religion in a public forum.
Well, there have been, there have been cases from the Supreme Court, I think in more recent years, cases like the Good News Club case, cases like the Trinity Lutheran case, cases like the Town of Greece case, where I think the Supreme Court has recognized the importance, of course, of religious liberty in the United States, and also has recognized, I think, that religious speakers, religious people, religious speech is entitled to a space in the public square and not to be discriminated against. I think the Trinity Lutheran case is an important one on that. The Good News Club case, that's a case where as an after-school program at a school gym, I think, or auditorium, and a religious group was excluded, and the Supreme Court made clear, no, you can't just exclude the religious group. So I think there have been some developments since then in terms of religious equality and religious liberty that are important. Those cases are always difficult factually, but the principle you're espousing, I do think, is reflected in some more recent Supreme Court precedent.
Well, I'll just conclude with this. As I understand the Constitution, it requires the government to be neutral.
Yes.
And as Chief Justice Rehnquist, I think in this case, the government evidenced hostility to religious speech in the public square. That's just one person's opinion. And again, I'm not asking you for any opinion with regard to a case that may come before the court. Mr. Chair.
And Citizens United, Save our democracy!
Mr. Chairman, I hope that time won't be subtracted from my 30 minutes.
It will not be.
Thank you. So, Judge Kavanaugh, I'm intrigued by a comment that you made earlier about the role of precedent. We've heard a lot about precedent. You alluded to this book that you and other judges wrote with Brian Garner on the law of judicial precedent. I checked it out. It's 900 pages long, and I haven't read every page of it either.
I don't think it's not meant to be read word for word. It's a treatise where you go to a section that might be on point or something.
But let me just ask you a more basic question, then we can work our way into that. When people go to court, should they expect a different outcome if the judge was nominated by a Republican from a court where the judge was nominated by a Democrat?
No. That's an important principle of the judicial independence and the judicial role. Well, the judge's umpire vision that Chief Justice Roberts articulated, and I've talked about publicly many times, is critical. When you go to a baseball game, the umpire is not wearing the uniform of one team or another, and that's a critical principle.
Well, it strikes me as an important point, given the suggestion that one of the reasons people have objected to your nomination is, I believe the quote was, you have Republican blood flowing in your veins. It strikes me as a strange and bizarre statement.
I've been a judge for 12 years, Senator, and I'm 307 opinions. I'm very proud of that record, and been an independent judge for 12 years. And as a judge, you're not a Republican or a Democrat as a federal judge.
And you talked a little bit about the constitutional basis for a judge's obligation to apply existing precedent. Could you expand on that a little bit more? Because I think most people are under the impression this is sort of a discretionary matter, and you can sort of cherry pick between what precedents you decide to follow and which ones you don't follow.
Well, there's been a debate sometimes about what are the origins of precedent? Why do you follow precedent? And as I see it, there are a number of reasons you would cite: stability, predictability, impartiality, reliance interests. But all of those are not mere policies in my view. As I see it, the system of precedent comes from Article 3 itself. When Article 3 refers to the judicial power shall be vested in one Supreme Court and such inferior courts as Congress shall from time to time establish. To my mind, the phrase judicial power, you think about what does that entail? And you look at the meaning at the time of judicial power, and you look, one source of that is Federalist 78. And that in Federalist 78, it's well explained that judges make decisions based on precedent. And precedent, therefore, as I read judicial power, has constitutional origins and a constitutional basis in the text of the Constitution.
And I think you've touched on this as well. Judges, unlike legislators, don't run for election. You don't have a platform.
No.
Vote for me. This is what I'll do if I'm elected into office. One of the most important elements of limiting the important role of judges, I think, under the Constitution is that you're required to decide a case on a case-by-case basis rather than issuing some sort of oracle saying, henceforth, the law will be thus, assuming you could get 8 other judges on the team of 9 you talked about to agree with you. Can you talk about the importance of deciding cases on a case-by-case basis?
We'll add another 20 seconds.
Thank you.
Absolutely, Senator. It's important to understand, and I think Senator Graham alluded to this as well. As judges, you don't just issue policies or issue opinions out of the blue. You decide, as Article 3 says, cases and controversies, and that means there's a process. Litigants come into the federal trial court, for example, and litigate against one another, and there's a process there, a trial or a summary judgment motion. The district judge renders a decision. Then that comes up to the Court of Appeals, in my case. and there's briefing and oral argument. I like to say there's a process. I like to say process protects you. It's one of my things I always like to keep in mind. You go through a process to help make good decisions, deliberative process. And we have a process. Judges were very focused on process. And having that oral argument, having the briefing, and then talking to your colleagues, you change your mind. You know, Senator, you've been a judge, of course. You change your mind sometimes based on the comments of colleagues. So that process is important. And then to your point about you're deciding that case, you write an opinion. You're not trying to resolve every issue imaginable in the opinion. You're trying to resolve this case under the principles and precedents, the text of the law in question, the text of the statute in question, and decide that case or controversy. And that's how judges build up a system of precedent over time, by deciding one case at a time and not trying to do more than they can or more than they should.
Majority of this committee or the Senate. You are dismantling our democracy.
And Judge, don't you think that what you've described for us in deciding cases on a case-by-case basis has an important foundation in fairness to the litigants, the parties that come to your court? Because how would somebody feel if they know you've already announced in all cases that have to do with subject X, I've made up my mind, I don't care what the facts are? Isn't that unfair to the litigants?
It can be, Senator, at least, where an overbroad ruling may resolve things that people who are affected by it may have thought, well, I wasn't part of that case. Why am I now affected in a particular way? I think one of the things I can say about how I've tried to write my opinions, the 300 opinions, is I'm always concerned about unintended consequences. This is one of the reasons I go through so many drafts of my opinions and really work through them, is even just a sloppy footnote or an ambiguous word in opinion. It's true when you're drafting laws here too, but if you don't, you're concerned about unintended consequences, which is why it's so important to be clear in the opinions and to be exactly precise and not to decide too much.
Stop Kavanaugh! Our bodies, our choice! Stop Kavanaugh! Our bodies, our choice!
Judge, let me ask you to tell us a little bit about September the 11th, 2001. Where were you when you heard that the planes hit the World Trade Center in Washington, D.C., and another plane hit the Pentagon here in Washington?
You know, I remember I was
New
in
York, I should say.
Yeah,
in Washington.
I was in the West Wing when they hit the second tower. I remember that, up in the upstairs counsel's office with a couple other people in the counsel's office, and then we were ushered downstairs and then told to get out and run out because there was fear, as we later learned, about Flight 93. I think don't know whether it was headed to the Capitol or the White House or some other target, of course. And the heroes of Flight 93 saved so many Americans. Sacrifice that, of course, we still all celebrate in the sense of celebrating their lives and their heroism for saving all of us here in Washington. But ended up out in Lafayette Park with the rest of the staff and bewildered. And changed America, changed the world, changed the presidency, changed Congress, changed the courts, all the issues that came before. It was a new kind of war, as President Bush described, with an enemy that didn't wear uniforms and that would attack civilians. And so new kinds of laws had to be considered, and Congress had to work through that. And President Bush had to focus so intently, and as I've said before, my remembrance is that on September 12th, his basic mentality was this will not happen again. And having traveling with him from 2003 to 2006 everywhere as staff secretary and seeing him up close, I still think every day I was with him during those years, every morning when he got up, it was still September 12th, 2001, this will not happen again. And to see that focus, of course, he had to do all the other things of the presidency, and all the other legislative and regulatory and ceremonial aspects. But he was so focused on that. I'm sure that's been true of the succeeding presidents as well, because the threat still exists, of course.
Well, as we came to learn, Osama bin Laden and al-Qaeda was responsible for that attack and has now morphed into other organizations like ISIS and the like. But I want to ask you, you had to then sit in judgment later on in a case, the Hamdan case, which you alluded to earlier, where the defendant was Osama bin Laden's personal bodyguard and driver. He was captured by U.S. forces in Afghanistan after 9/11 and detained in Guantanamo Bay. He subsequently went through a military tribunal, and then that case was appealed to your court. And just correct me if I'm wrong, but notwithstanding the experience you and everybody you cared about having been through this terrible travesty of 9/11, you ruled in favor of Osama bin Laden's bodyguard and driver, correct?
That is correct. I wrote the majority opinion.
How could you do that? How could you possibly do that?
The rule of law applies to all who come before the courts of the United States.
Even an enemy combatant?
Equal justice under law. Everyone is entitled to...
Even a non-citizen?
Yes. Non-citizens who are tried in U.S. courts, of course, have the constitutional rights. And really my model on that, judicial model for thinking about something like that, because I thought about what you're asking about. Justice Jackson, of course, Robert Jackson, who had been Franklin Roosevelt's Attorney General, that he's in the Korematsu case, even though that was one of President Roosevelt's policies. Justice Jackson, now the majority opinion now overruled, but Justice Jackson dissented and ruled against the Roosevelt policy. Justices Clark and Burton, two appointees of President Truman, are the two deciding votes in Youngstown Steel. That's a 6-3 decision. Those two are the deciding votes, therefore. They both were appointees of President Truman. They get to and it's wartime against Korea. They get to the Supreme Court. They're the deciding votes in the Youngstown Steel case, which was an extraordinary national moment, one of the great moments. And so it's your conception of the role of a judge it's about the law. That's distinct from policy, and our judiciary depends on having people in it, and we are fortunate to have a wonderful federal judiciary, people in it who understand the difference between law and policy and are willing to apply principles of equal justice under law to anyone who comes before the court. Even the most unpopular possible defendant is still entitled to due process and the rule of law, and I've tried to ensure that as a judge.
Well, it's hard for me to imagine a more unpopular defendant than Osama bin Laden's driver and personal bodyguard. So I find the suggestion that somehow you are prejudiced against the small guy in favor of the big guy, or that you are picking and choosing who you're going to render judgment in favor of based on something other than the rule of law. I think this answers that question conclusively for me. The fact that you could separate yourself from the emotional involvement you had, along with so many people you worked closely with in the White House on September the 11th, and you could then, as a judge, after you put on the black robe and take the oath of office, you could then render a judgment in favor of Osama bin Laden's bodyguard and driver because you apply the law equally to everybody that comes to your court. Sometimes well, let me allude to something Senator Sass, I think, was eloquently speaking about yesterday in terms of the separation of powers. Very important aspect of our constitutional system, and one that I know you've dealt with often on the D.C. Circuit Court of Appeals. And that has to do with what I've read some judges talk about, some constitutional scholars talk about a conversation between the branches. In other words, when the D.C. Circuit Court or the Supreme Court decides a case, they finally decide that case, but they don't finally decide what the policy is for the United States or the American people, correct?
That's correct, Senator. And I think one of the important things that judges can do is adhere, of course, to the laws passed by Congress, but then in writing the opinion, make clear, and I've done this before, and a lot of my colleagues do this, is that perhaps the statute needs updating, but if it does, that is the role of Congress to update the statute. Or if there's sometimes there'll be a hole in a statute or something that seems unintended in a statute, and to alert Congress to that. Chief Judge Katzmann of the Second Circuit, who's a great judge I serve with on the Judicial Branch Committee, which is appointed by the Chief Justice, and he has written a book about statutory interpretation, but he's also been a leader of a project to make sure that Congress is alerted of potential statutory issues that look like they might have been things that perhaps Congress would not have intended, or at least Congress would want brought to its attention so it could fix. And so that project's been very successful. I think Chief Judge Katzmann's project, and it's one, even without that project, how you write your opinions, I think, is important. We don't update the statutes, you update the statutes, but it's good for us to write our opinions in a way that points out potential issues that Congress might want to be aware of.
And that's part of the conversation between
Yes.
the two co-equal branches of government.
Absolutely, and I think that's an important dialogue to have between Congress and the judiciary, and the back and forth is very important on that front. And I think that's one thing I'm always thinking about in my opinions. You write the laws, but if the law looks like there's some issue with it, some flaw or something that might be an unintended consequence, in the opinion you can identify it, and that can be something that Congress can turn its attention to sometimes. Because I'm well aware that statutory drafting is a very difficult process. That's something I think judges need to be actually more aware of, is how difficult the legislative drafting process is. Even if you're doing it as one person, it would be difficult, but then you're doing it as a collective body, and then you're doing it with the House and with the president involved. There are a lot of people in, and it's hard to have, with all the compromises inherent in that, hard to have crystal clarity on every possible topic. So as judges, I think, number one, we have to recognize the process that you go through as legislators. That means adhere to the compromises that are made, the text as written, but also when we write our opinions, if there seems to be something that's not working out, it's appropriate, I think, for judges to point that out in their opinions.
And of course, even if it's a constitutional basis for your decision, that could be changed by constitutional amendment, correct?
Well, that's correct as well. The framers did not think the Constitution was perfect by any stretch. They knew it had imperfections. For starters, the original Constitution did not have the Bill of Rights, the first 10 amendments. So there was a lot of discussion at the ratifying conventions about having a Bill of Rights. And that was quickly done in the first Congress in New York in 1789, of course, with James Madison taking the lead on that. But so, too, they did not think it was perfect. They have an amendment process that's specified in Article 5 of the Constitution. And that amendment process was intended to be used, and we've seen it used to correct structural issues, the 12th Amendment on presidential elections, the 17th Amendment, of course, as you all know well, on Senate elections, the 22nd Amendment, which limited presidents to only 2 terms, the 25th Amendment, which corrected some issues with respect to vice presidency, and so too, of course, the 13th, 14th, and 15th Amendments, the most important amendments in the Constitution in many respects, because it brought the promise of racial equality that had been denied at the time of the original Constitution into the text of the Constitution. So the job of the people which is the Congress and the state legislatures, is to amend the Constitution. It's not the job of judges to do that on our own. And obviously that's a basic divide of constitutional responsibility that is set forth right in the text of Article 5 of the Constitution.
I can't remember who said it. I think Justice Jackson, perhaps, who said the Supreme Court is always right, is not final because it's always right. It's right because it's final, or words to that effect. But I always thought the more I got into that, the more I disagreed with that, because it is a conversation between the branches. And if the American people believe that as a constitutional matter, the way the Constitution is being interpreted, it's within our power as the American people to change our own Constitution by amendment. There's provisions in the Constitution itself to do that. It's hard, and it should be hard, but ultimately, the authority that we delegate to the government finds its origin in the consent of the governed. It's not something dictated to us from down on high, from the Marble Palace or somewhere like that here in Washington.
Well,
it is ultimately our government, our responsibility, our authority that provides legitimacy to the government itself. You agree with that?
I agree, of course, with that, Senator. The people, we the people, form the Constitution of the United States, and the sovereignty, the people are the ultimate authority. And you're right about Justice Jackson's line. I think it is a clever line. But ultimately, I agree with you. I've always had a little bit of a problem with that line, because we're infallible because we're final. No, both parts of that are wrong in some sense, because I never want to think of the court as infallible. And I also never want to think of it necessarily, in the way you're describing either, because there is the people always have an ability to correct through the amendment process. Now, the amendment process is hard and hasn't been used as much in recent decades. But of course, at the beginning of the country, the amendments were critical. And Dred Scott, of course, the awful example of just a horrific Supreme Court decision that is then corrected in part, at least on paper, in the 14th Amendment, 13th, 14th Amendments. And that's an important example, I think, of probably the best example, frankly, of the point you're making about the people being able to respond to a horrific decision of the Supreme Court.
Well, in fairness to Justice Jackson,
yes,
maybe he was thinking, as I originally thought, about the expression as being binding on lower court judges, trial judges, appellate court judges, and the Supreme Court does have the final word in that food chain of the judiciary, but not in terms of the fundamental authority of the American people to decide what laws should govern them.
I think that's probably right, Senator. I don't want to be Justice Jackson's one of our greatest justices. To question anything is whether it was Korematsu dissent or Barnett or Youngstown or Morissette on mens rea. Justice Jackson wrote some of the greatest opinions and the example of judicial independence as well. So, but on that one line, I take your point.
Let me just ask you one last question. We've talked a lot about the role of precedent, and Senator Feinstein talked about stare decisis, and basically cases that have been decided provide the precedent for future cases. But on occasion, the Supreme Court has decided that its decisions were just wrong and chosen to overrule those previous decisions. I'm thinking of Plessy versus Ferguson, for example, which was a scar on our body politic that said that separate but equal educational facilities met the constitutional requirement of the 14th Amendment. But can you talk about the extraordinary circumstances under which the Supreme Court would revisit a precedent?
Well, Brown versus Board of Education, of course, overturned Plessy. And Plessy was wrong the day it was decided. It was inconsistent with the text and meaning of the 14th Amendment, which guaranteed equal protection. And the Supreme Court in the Strouder versus West Virginia case in 1880, jury selection case, had said, what is this amendment but that the law shall be the same for the black and the white? and the Supreme Court, unfortunately, backtracked from that clear principle in the Plessy decision, and a horrific decision which allowed separate but equal, and then Brown versus Board corrected that in 1954, of course, corrected it on paper. It's still decades, and we're still seeking to achieve racial equality. The long march for racial equality is not over, but Brown versus Board, as I've said publicly many times before, the single greatest moment in Supreme Court history by, in so many ways, the unanimity that Chief Justice Warren achieved, which is just a great moment, the fact that it lived up to the text of the Equal Protection Clause, the fact that it understood the real-world consequences of the segregation on the African-American students who were segregated into other schools and stamped with a badge of inferiority. That moment in Brown versus Board of Education is so critical to remember, and the opinion is so inspirational. I encourage everyone to, it's a relatively short opinion, but it's very powerful. It's very focused on the text of the Equal Protection Clause and correcting that awful precedent of Plessy versus Ferguson, a great example of leadership. And just the last point I'll mention on process, they knew they were going to face popular backlash. They knew they were but they still did it. So that shows independence and fortitude, but they also had re-argument, which I think is they had argument originally and then decided there's a lot going on and maybe not everyone's seen it the same way, the justices, and they had a re-argument, which I think is a good lesson on process protecting us, and keep working at it and see, the team of 9 that I mentioned yesterday and I mentioned today, keep working at it as a team of 9, and they came out unanimous. Chief Justice Warren thankfully led the court in that decision. That was a great moment, the greatest moment in Supreme Court history.
Thank you, Judge.
Thank you. I awarded 2 additional minutes to Senator Cornyn because he was interrupted by my count 5 times during his testimony. Senator Whitehouse is next.
Thank you. Good afternoon, Judge Kavanaugh.
Thank you, Senator.
Are you good for another half hour?
I'm good.
All right, good. In my office, you told me that you could provide no assurance to me that you'd uphold a statute requiring insurance companies to provide coverage for pre-existing medical conditions. Is that still true here in public?
Well, I think, Senator, it's important to understand the principle at play here. The principles.
We've talked a lot about that, but is the statement you made, have I recited it accurately, and is it still true today that you can give no assurance that you would uphold a statute?
Well, Senator, judges like to explain their decisions.
Yep, but I get to ask the questions. Usually you get to ask the questions because you're the appellate judge, but today for half an hour I get to. So is it still true that you can give no assurance that you would uphold a statute requiring insurance companies to cover pre-existing medical conditions?
So to prepare for this moment, I went back and read.
I really would like you to be as careful with your time as you can, because I have a very limited amount of time with you. So the quicker you can get to the answer, it could be as simple as yes or no.
But I can enhance your understanding of my answer if I explain it, I think.
I really just want your answer on the record. I think I'm pretty capable of understanding it on my own.
But, well, then everyone to understand my answer. So there's nominee precedent of how justices and nominees in my position have answered in the past. I'll be succinct if I can. And all 8 sitting justices.
I know, you've actually said this in the hearing, so people who are listening and interested have actually already heard you say this.
Well, I think it's really important, so I want to
say it again then.
I want to underscore it. All 8 sitting justices of the Supreme Court have made clear that it would be inconsistent with judicial independence, rooted in Article 3, to provide answers on cases or issues that could come before us. Justice Ginsburg, no hints, forecasts. Justice Kagan talking about precedent, no thumbs are up or down. And I went back. Justice Thurgood Marshall was asked repeatedly in his hearing, what do you think about Miranda? What do you think about Miranda? What do you think about Miranda?
Got it. Everybody else does it, and your answer is still no.
So the reason everyone else does it, though, is rooted in judicial independence and my respect for precedent. So it's a combination of my respect for precedent, nominee precedent, and my respect for judicial independence. So I can't give assurances on a specific hypothetical.
Okay, thank you. Let me go on to another subject, which is executive privilege. Executive privilege is a principle that is founded in the Constitution and the separation of powers, correct?
The Supreme Court so ruled in the United States versus Richard Nixon case. So that was the first, the key issue in the United States.
That's all right. I just needed the answer to the question, and you've answered it.
The source is important.
As a privilege, it needs to be asserted. Does it not? That's true of privileges generally.
I don't know where this is going, but the
pretty straightforward question. Don't privileges need to be asserted in order to apply?
Well, privileges are recognized
Once they're asserted.
I think as a general proposition.
Fair enough. I'm only asking as a general proposition.
Yes, an attorney-client privilege, you would assert the attorney-client privilege. Yeah.
And who asserts executive privilege?
Ordinarily, well, that is a complicated question, Senator. Actually,
Who does it come back to? Ultimately, who asserts executive privilege?
So it depends what you're talking about. So what kind of executive branch document you're talking about, it depends. In my experience,
ultimately it's the president.
There's not as much precedent on that. There's some. In the Supreme Court, this was the Supreme Court in the United States versus Richard Nixon.
Isn't it fair to say that executive privilege belongs to the president of the United States, the chief executive?
Yeah, it can also belong to the former president in the case of former presidential records. That's one caveat I want to put on that.
Fair caveat. Yeah. Is the assertion of executive privilege by the president subject to judicial review?
Well, of course, because under the precedent, United States versus Richard Nixon said two things. It said, one, the executive privilege is constitutionally rooted. The special prosecutor in that case argued that actually there was no such thing as executive privilege. And the Supreme Court rejected that argument and held that the executive privilege is rooted in the separation of powers and in Article 2. But
the reason I'm asking doesn't have much to do with you. It goes back to a point that we were talking about earlier in the hearing, which is that we have received hundreds and hundreds of pages of documents of your record that look like this. They both say committee confidential across them at an angle, and then across the front they say constitutional privilege. And as a member of the Senate, this is not a question, I'm speaking to my colleagues, I find myself in a quandary here about being denied those particular documents because I cannot find any assertion of the privilege. These documents just suddenly appeared and somebody had put constitutional privilege on the page and wiped out all the text that was on the page. And my understanding is that there's ordinarily a process for getting to that determination that allows for ultimately a judicial review. And we have failed to get subpoenas out of the committee for documents, so we can't trigger it that way. And there's no apparent assertion of executive privilege that I can find in the record of how this particular paper got here. So I just wanted to establish some of the basic ground rules of executive privilege with you, because I think we agree on that. I think that's basically commonly agreed, and put that into the context of what we are looking at. And particularly with respect to Chairman Leahy's questioning earlier, if some of the documents he's looking for have now been protected by this non-assertion assertion of executive privilege, we have a problem. It is a continuing problem in the committee. We've had other witnesses come and do non-assertion assertions of executive privilege, and so I'm sorry to drag committee business before you, but I do think it is important that we try to get this right.
Can I make one addendum based on my experience from the time, which is I don't think formal assertions usually occur until after there has been a subpoena, at least from my time working.
Which is why not being able to get a subpoena kind of bollockses up the process. Yes, indeed. Yeah. The role of the Federalist Society in bringing you here today has been of interest to me. As you know, we spoke about it quite a lot when you and I met in my office. Mr. McGahn, who is sitting very patiently behind you, I can see him over your shoulder,
Yes.
Has said that the Federalist Society was insourced into the White House to make these recommendations, specifically to make the recommendation that you should be the nominee. You have said this regarding President Bush, that he thought it was, and I'm quoting here, improper to give one group, especially a group with interests in many issues, a preferred or favored position in the nomination process. Those were your words, speaking, I guess, to the Federalist Society National Lawyers Convention. On another occasion, you wrote a draft speech for Attorney General Gonzalez or White House Counsel Gonzalez, probably White House Counsel Gonzalez, look at the date, to deliver to the Federalist Society. And you said in that speech, as a matter of constitutional principle, it is simply inappropriate, we believe, to afford any outside group a quasi-official role in the president's nomination process. How do you square those two comments about the role of the American Bar Association in the nomination process with the role of the Federalist Society in your nomination process, assuming that Mr. McGahn was speaking accurately when he said they had been insourced to the White House for this process?
Right. So I can speak to the ABA part of that. President Bush in 2001 had to make a decision of how the ABA should play its usual rating role with respect to nominees. And the ABA files amicus briefs and takes policy positions on issues. And therefore, after some deliberation, it was decided that there was nothing wrong with the ABA rating the nominees, but to give an organization that files amicus briefs and takes policy positions a preferred role in the constitutional nomination process was unfair in some ways and favoring.
Would it be a fair description of the Federalist Society's role in your selection as the nominee to say that it was preferred over other groups?
Well, my experience was when Justice Kennedy retired on the Wednesday, Mr. McGahn called me later that afternoon, said we need to talk on Friday. He came over to my office on Friday evening or late afternoon. We talked for 3 or 4 hours, interview and going through the usual kinds of questions you would go through when you're embarking on a process like this. And then I met with interviewed with the president on Monday morning.
So is it your testimony that you don't know what the role of the Federalist Society was in your selection?
My experience and of my personal experience and what I know is that President Trump made the decision, for starters. President Trump made the nomination. And I know he, as I explained yesterday, I know he spent a lot of time in those 12 days on this issue, and I was aware of that. I also know that Mr. McGahn was directly involved with me and spent a lot of time on it. And I also know that the vice president.
You have no knowledge to share with us today about the role of the Federalist Society and how they were insourced into the White House. That is a mystery to you as well as to us.
I'm not sure what Mr. McGahn meant. I think by that comment, I think Federalist Society members are lawyers in the administration are Federalist Society members, and so it should not be a surprise that because it's an organization.
And Leonard Leo's role specifically from the Federalist Society?
I don't know.
Okay.
I don't know the specifics.
Well, let's go from specifics to generals, and let me put up a graphic that shows some of the folks who fund the Federalist Society. It's a pretty significant group of people who tend to share very conservative and pro-corporate points of view. It reflects that at least 14 of the donors are actually anonymous, which is a very unfortunate part of our current political world. Actually, probably more than that, because Donors Trust here is an organization whose sole purpose is to launder the identity off of big donors so that a recipient of funds can report that they got the money from Donors Trust rather than the true party in interest. So we don't know how much anonymous money flowed through them. But I would contend that this is a pretty strong group of right-wing conservative pro-corporate funders. And presuming that to be true, should that give you or anyone in this process pause that groups like this may have had such a significant role in selecting you to be in this seat today?
Senator, Mr. McGahn was the one who contacted me. I interviewed with the president, and I know the president was, I'm the president's nominee. He was directly involved in making that decision. I'm sure he consulted with Mr. McGahn and others. I know he consulted widely with a lot of people to get input on the, very widely to get input on the, at least the people who were the finalists. So that part of it, my 12-day experience was with the White House counsel's office and the president and vice president too.
Okay, so
and I also don't. I'm not familiar with all
whatever
those
the
groups
role is
or
of the Federalist Society was in all of this, it was, and there's plenty of reporting. We don't need to litigate that between us. You don't know, it's what you've testified, and that's fine.
On my process, and again, yes.
But you're fairly familiar with the process generally because you used to run it in the Bush White House or have a significant role in it, the process of judicial nomination selection, judicial nominee selection, correct? You've been inside that machine.
I did not run it, and Judge Gonzalez, when I was in the counsel's office, was the counsel.
But you've been inside the process.
I have been inside the process, yes.
So the next thing that happens going forward is that we see the Judicial Crisis Network showing up, and they spend millions and millions and millions and millions of dollars to run ads urging senators to support you. Now, I don't know whether we can show that those were the same funders because they are engaged in what is called, as you know, dark money funding. They don't report their donors. But I'd be prepared to make a very substantial bet that there's enormous overlap between the funders of the Judicial Crisis Network campaign for your confirmation and the Federalist Society donor group, to the extent that we're aware of it, since so many of them are anonymous. Hypothetically, should the American people have concern about the role of very, very big spenders and influencers doing things like being involved in the selection of a Supreme Court nominee and running dark money campaigns to support the confirmation of a nominee? Is there any cause for concern there as a general proposition?
Well, Senator, there are a lot of premises in your question that I'm not sure about.
I'm not asking you to accept the premises as true. I'm asking it as a hypothetical.
Well,
if there were very, very significant big special interest funding behind the organization that was responsible for selecting you and recommending to the president that he nominate you, and again, from a very similar group in supporting the dark money campaigns that are being running on your behalf for your confirmation, would that be a matter of concern, or is that all just fine and we shouldn't even care about getting the answers?
So two things, Senator. One is I've described the process I went through with Mr. McGahn, the president, and the vice president, in the selection, and that's what I know about my process. Two, on the ads, there are a lot of ads against me as well, and I've seen those, and you know, our family's seen those, and then there's ads for me, and we've seen those too. And as Chief Justice Roberts said in his hearing, it's a free country, and there are ads for and against, and obviously we've, as Senator Durbin said,
should we as citizens know who they are, who's funding the ads, just as a matter of citizenship? Is that?
Well, I think that's first and foremost a policy question for the Congress to decide on what disclosure requirements it wants to put in. And then if those disclosure requirements were put in, or state governments could try to make disclosure requirements, I think some have tried, and then there would undoubtedly be challenges to that. And what's the First Amendment implications of that? And that would come to a court. And I would keep an open mind on that case under the precedent and First Amendment law, and we would think about that. The policy question, I think, is really for Congress in the first place to determine, assess, study exactly what kind of disclosure requirements should be put in place. I understand.
The potential hazard there is that the unleashed power of unlimited political dark money then becomes like a ratchet, the obstacle to solving that problem. And I hope you can understand that as a matter of political principle.
I do understand the concerns about money in the political system. When I worked for, and the time it takes all of you, and when I worked for President Bush in the 03, 04 timeframe, for example, and how many fundraisers he had to do, and going back to the September 11th point and the time and burdens on the presidency, he had to do a lot of fundraising, running for president while being president.
It's gotten a lot easier since now you can just get a huge special interest to set up a 501c4 and drop tens of millions of dollars in, and it's like that, and the public doesn't know who's behind it. Only a very few people are in on what the deal is. So it's gotten easier since President Bush, but not better.
Well, I think for some members, particularly in the House, if you're running for re-election and a third-party group comes in against you, you have to go out in the fundraising and spend even more time. I think that, at least as I understand, that's part of the concern I've heard over the years, just generally, is the time that each of you has to spend and the members of the House have to spend.
So let me just continue on forward through this problem of funders. On the court, on the D.C. Circuit, and potentially on the Supreme Court, you will often see cases brought by groups like, for instance, the Pacific Legal Foundation. Are you familiar with that group?
Yeah, I've seen briefs by the Pacific Legal Foundation.
Do you know what they do?
I'll take your description.
Okay, my description is that they get money from right-wing, conservative, and corporate interests, and they look for cases around the country that they believe they can use to bring arguments before the court. I argued against them in the Supreme Court at one point. They came all the way across the country to the shores of Winnipesaukee Pond, Rhode Island, to hire a client whose case they could take to the Supreme Court with a purpose to make a point. And they're not alone in doing this. There are a number of similar groups who perform this service. And it causes me to think that sometimes the true party in interest is actually not the named party before the court, but rather the legal group that has hired the client and brought them to the court more or less as a prop in order to make arguments trying to direct the court in a particular direction. Is that an unreasonable concern for us to have about the process?
Senator, I think there are public interest litigation groups spanning the ideological spectrum that look for cases to weigh in on as amicus briefs, and they're also, of course, there have been historically, you look for, as I understand it, people try to identify suitable plaintiffs to challenge, and this again is across the entire ideological spectrum.
What are the signals that that's gotten out of hand? That there's something rotten in Denmark?
That's an interesting question, Senator, and I think it's an important one, but it's not one that I think I have a great answer to.
Well, let me propose one thought to you, which is that the Supreme Court, at least, should fix its rules on who the amici are who turn up and require some disclosure of who's really behind them. The only thing the Supreme Court requires is to disclose who paid for the brief. The brief itself is not a very big expense. And so very powerful interests can come in behind an amicus group that has a lovely name like Citizens for Peace and prosperity and puppies, and nobody knows who's really in interest. So that would be one thing that I think would be a concern. Another thing that would be a concern, I would think, would be when you see these special interest groups rushing out trying to lose cases in order to get before a friendly court. It really seems improbable as somebody who has actually tried cases and who's been around courtrooms a lot and who's seen a lot of litigation, a lot of great litigators. I have never seen anybody once try to lose a legitimate case. So in the wake of Justice Alito's signaling about what then became Friedrichs and Janus, to see these groups rush out and ask the court to rule against them so they can get hot foot up to the Supreme Court where they expect a good outcome, to me, that there's just something that doesn't seem right about that. That seems to me a little bit like faux litigation, that there's something else going on other than real parties having real arguments and the Supreme Court ultimately settling properly prepared real disputes. Do you have any concern about the optics of people rushing to lose cases below to come before what they think is a friendly Supreme Court? Does that seem just a little bit odd?
I will acknowledge. I'll acknowledge, Senator, I'm not entirely familiar with that phenomenon. I would be interested in more.
I might follow up with you with a question for the record to get your more deliberate thoughts about it.
And on your amicus thought, I'm interested in the specifics of your proposal, and certainly, if confirmed, I would.
Because here's the concern. You know perfectly well that the court depends on, as much as anything, on its reputation. You don't have a purse and you don't have an army. Yeah. You stand on your reputation in the judiciary. And you must not only act justly, but be seen to act justly. And what I've laid out is a scenario in which very big special interests have a significant role in funding the group that I believe, and much reporting says, is responsible for getting you to the top of the greasy pole of nominee selection. Yeah. And that the same funders are behind the Judicial Crisis Network operation that is politically pushing for you. That the
Senator Whitehouse, we're going to add 1 minute to your time. You've been interrupted twice.
That some portion of the Supreme Court's docket is made up of strategic cases rather than real litigation in which somebody has gone out to find an appropriate.
We want to break away for a moment from the Kavanaugh hearing to take you to the White House. Just moments ago, the president praised his Supreme Court pick. Let's take a listen.
He's an outstanding intellect. He's an outstanding judge. He was born for the position. I heard as long as 10 years ago, people were saying he should be a Supreme Court judge. I didn't know him at the time, but I was hearing from a lot of people, friends of mine from Washington and other places, saying that Brett Kavanaugh should be a Supreme Court judge someday, and I'm honored that I gave him the chance. I've watched his remarks, I've watched his performance, I've watched his statements, and honestly, they've been totally brilliant. I think that the other side is grasping at straws, and really the other side should embrace him, because you're never going to find better in terms of talent or intellect than what you have in Brett Kavanaugh. Okay? Oh, yeah, sure, he's lying, sure. No, Bob would, no, the book, you mean on the book?
Yes, the book, yeah.
The book means nothing. It's a work of fiction. Already General Mattis has come out very, very strongly, and I think you know General Mattis. He does what he wants to do. He's a very independent guy. He was insulted by the remarks that were attributed to him, and he came out with a very strong statement. I assume you read it. I hope you read it last night. General John Kelly, the same exact thing. He thought he was insulted by what they said. He's right here. He's insulted by, he couldn't believe what they said. and he put out a very, very strong statement, and many others, and other statements are coming out. The book is a work of fiction. If you look back at Woodward's past, he had the same problem with other presidents. He likes to get publicity, sell some books, but we have done more as an administration than any other administration in already less than 2 years. It's incredible. We will soon be approaching 2 years. But there's no administration, probably, and even you folks have generally acknowledged this, that has done more work. When you look at tax cuts, regulation cuts, Supreme Court justices, the court system generally, and so much more, even if you look at the health care programs that we're passing, and all of the things we've done, we're saving Social Security. The Democrats will destroy Social Security. We're saving Medicare. The Democrats want to destroy Medicare. You look at what they're doing, they're going to destroy Medicare, and we will save it. We will keep it going. We're making it stronger. We're making Social Security stronger. We're making our whole country stronger. So all you have to do is look at the achievements. But I was very honored when, without my even knowing about it, statements were put out by General Kelly, by General Mattis, highly respected people by everybody, including yourselves. And the book is a work of fiction. It really, if you look at it, it was put out to interfere, in my opinion, at this time with the Kavanaugh hearings, which I don't think it's done, because so many people have come out against it. So many people who have been written about said that I never said that. Rudy Giuliani is another one. He's very insulted by the book and what was stated in the book. So we do run a strong White House, there's no question about it, and we are doing things that nobody else has ever been able to do, and our country is stronger now than it's ever been, and in a very short period of time, $700 billion being spent on the military, the next year $716 billion. We will actually be far stronger than we've ever been, and that's what we need it to be. Thank you all very much. Oh, we have a great relationship. First of all, I have a great personal relationship with the Emir, and Kuwait is a place that I've known for a long time. I have many friends that live in Kuwait, and they live, frankly, in Washington and New York mostly, that I know, and I've known them for a long time. Very, very fine people. Our relationship and our bilateral relationship is very, very powerful, very strong. And they view us as a place where they've done very well, and they like to invest their money in the United States, and we like that. So Canada's meeting with us right now as we speak. We have to make a fair deal with Canada. As you know, they charge tariffs of 300% on dairy products, which a lot of people never understood. They have walls up against us doing business in Canada, and yet they come and do business with us, and we can't let that happen. Look, we have a very strong position, and we are the one that people want to come in and take advantage of. They've been taken advantage of. Along with it, I'm not blaming Canada. I love Canada. I love the people of Canada. But they and other countries have been taking advantage of the United States for many years, and this is a president that has stopped it. We've made a deal with Mexico, and Mexico's been terrific to deal with, including their new president, who I spoke with, and I think we're going to have a very good relationship with Mexico going forward. And the deal is a much more fair deal between the United States and Mexico, because NAFTA goes down as one of the worst trade deals in the history of our country. It emptied out millions of jobs. It emptied out factories and plants all over the United States, and it was a very unfair deal and a very foolish deal, and in fact, you could say a very stupid deal for the United States to make. We are straightening out these horrible trade deals. As you know, we had 4.1 GDP. It was just raised to 4.2. Nobody thought that was possible. When the trade deals are fixed and made fair, GDP will go even higher and potentially much higher than that. And if you go back to election and go back to campaigning, nobody ever would have said that was possible except me and maybe a few others that believe in me. Thank you all very much. It's possible. Anything's possible. Anything is possible. We'll see. Say it,
I
what?
asked you about Syria.
What?
About
North
Syria.
Korea?
No, Syria. When President Assad challenges you.
Did you say Syria?
Yes,
Yes.
if he attacked Italy.
I think it's a very sad situation in Idlib and the province, what's going on there. It's being surrounded, and they feel they have 35,000 of their enemy there, and yet you have 3 million people living there. And I just tell you that they will hopefully be very, very judicious and careful, because the world is watching. That cannot be a slaughter. If it's a slaughter, the world is going to get very, very angry. And the United States is going to get very angry too. Okay? I am watching that very closely. So it's surrounded right now, and the province, and it's surrounded by a lot of people with a lot of weapons. And these are innocent people. You have 3 million, at least, innocent people there. And you have to be very, very careful. And the world is watching, and the United States is watching very closely. Thank you very much, everybody.
Let's go. The assassination of President Assad. Did you suggest the assassination of President Assad?
Not at all. No, the book is fiction. I heard somewhere where they said the assassination of President Assad by the United States, never even discussed. The book is total fiction. Just like he wrote in the past about other presidents, you look at what he said about President Bush, what he said about President Obama, big scandalous thing, big. It lasts for about a day. No, that was never even contemplated, nor would it be contemplated, and it should not have been written about in the book. It's just more fiction. The book is total fiction.
Will you sue, sir? All right, guys, let's go.
Thank you very much.
Are you going to get personally involved? Come on, make your way out. Let's go.
Thank you very much.
President Trump weighing in there on Bob Woodward's new book, calling it pure fiction, also saying he's been watching the Brett Kavanaugh hearings on Capitol Hill, saying that he's pleased with it. I want to take you back now to those confirmation hearings currently underway.
6-3. Now, even in those cases that are decided 5-4, does the fact that it was decided 5-4 make it any less of a legitimate decision? Does it make the judgment any less binding on the parties in that case?
No, it is still a decision of the court, no matter what the ultimate majority opinion is composed of.
And would it behoove a lawyer who is an officer of the court to call into question the subjective motivations of a court simply because of the fact that the court decided a case on a 5-4 basis?
Well, if I were a lawyer arguing before the Supreme Court, I probably would refrain from questioning the motivations of the justices. I think each of the justices, I know them, they are all committed to the Constitution of the United States and impartially discharging their duties. Of course, have different perspectives on certain issues, but they're all, I think we're fortunate to have eight hardworking justices who have outstanding records and are committed to the Constitution and committed to the independence of the judiciary.
What about in the circuit court, in the D.C. Circuit where you have served? Would it be fair to suggest that a case is somehow less legitimately decided if that case were decided along the lines of which president appointed which member of the D.C. Circuit?
The precedent stands either way.
Thank you. I want to get back to a separation of powers point that has come up along various lines of questions asked by my colleagues today. Is the Constitution relegated to the judicial branch? Is it something that is to be upheld and interpreted only by those who wear black robes?
No, Senator. Let me take you through the process, I think. So Congress, of course, passes laws, and in considering laws, Congress will also often assess the possible constitutionality of the laws passed. So in the first instance, when you're considering the passage of a law, you might assess the First Amendment implications, or if it's a national security, the Fourth Amendment implications, and or the due process, Fifth Amendment implications.
And we've all taken our own oath to uphold the Constitution.
Right. So you do your best, and then the executive branch as well. They're constitutional, whether to sign the bill, for example, for the president, if the president has a constitutional concern or a policy concern, but the president could veto the bill for that reason. That has certainly happened historically. And then when it comes to the court, of course, we assess in cases or controversies the constitutionality of a law that is challenged there in the context of a specific case or controversy. We don't, President Washington, George Washington, asked the Supreme Court for an advisory opinion in his first term on a disputed legal issue. Actually, might have been his second term, but President George Washington asked for an opinion. The Supreme Court respectfully wrote back and said, we don't provide advisory opinions on, we only decide cases or controversies, thereby, I think, underscoring the point you're making with your question, which is constitutionality of laws is assessed in the first instance by Congress and the executive.
So it would not be inappropriate for us as members of the legislative branch to decide to protect something that we believe is constitutionally protected, regardless of where we might place our bets on what the courts would do with it. If we see a particular right that might be jeopardized by an act of Congress we are considering, wouldn't be inappropriate for us to say, look, we're not sure exactly how far the Supreme Court will go here. Out of an abundance of caution, out of respect for the Constitution, we're going to draw the line more carefully so that we make sure that we don't step into unconstitutional territory.
That has happened historically and I think happens today. And that underscores how the Constitution tilts toward liberty in so many different ways. It tilts toward liberty because it's hard to pass a law, as you know, with both houses and the president. And then not only might there be policy objections, but members of Congress might say, well, even if the Supreme Court would uphold this law based on my assessment of the Supreme Court, I have a First Amendment objection, Fourth Amendment objection, Eighth Amendment cruel and unusual punishments clause objection, equal protection objection, and based on my view of the Constitution, I'm going to vote no on this law. That's another way in which the constitutional structure all fits together and tilts toward liberty.
For that very reason, it would probably lead to some bad results if we were to not do that. In other words, if we were always inclined to say, let's just pass this. If it's unconstitutional, the court will do something about it. Can you foresee instances in which that could create problems?
Yes, Senator. I think Justice Kennedy has written eloquently about this. Each official, each officer in Congress, each member of Congress, each senator, the president takes an oath, of course, a constitutional oath, to abide by the Constitution. And that's very important for each member to understand and underscore, as I know all of you do. And that is an important part of the separation of powers process. I don't think that the framers thought, well, let's pass something even though we ourselves, meaning the members of Congress, think there's a constitutional problem here. And that's not how it has worked historically, nor do I think that's how the framers necessarily intended for Congress to work.
And there are myriad instances, moreover, in which we might enact something that for one reason or another might not be challenged for a long time, or might be difficult to challenge due to justiciability issues, somebody lacking standing, absence of a ripe controversy, and so forth.
That particularly happens in the national security context, I think, Senator, because there's often not someone with standing, especially if it's something being done in a foreign country against foreign citizens, that might be difficult to get into court in some way or another.
One of the reasons I focus on this today is that there was an exchange you had with one of my colleagues earlier today about the indefinite detention of American citizens apprehended on U.S. soil. Mm-hmm. There was some discussion surrounding this, suggesting that ex parte Curran might somehow justify this. You don't need to respond to this, but I think it's a point that needs to be mentioned. That Justice Scalia mentioned in his dissent in Hamdi that ex parte Curran was not this court's finest hour. And in fact, what happened was the case was argued. It was decided the next day. The saboteurs were taken out and executed the next week. Then the opinion itself was issued many months later. So again, I'm not asking you to opine on the ongoing validity of ex parte Curran, but the point is you seem to agree that Congress certainly has the authority to protect liberty, notwithstanding the possibility that the Supreme Court might not step in a particular case.
Absolutely. A couple of points in response to that, Senator, if I might. Justice Scalia, of course, dissented in that case, joined by Justice Stevens. One of his more powerful dissents on individual liberty.
You will only protect corporations and its archaic worldview. You will not protect the Constitution. The American people have no faith in you, sir.
One of his more powerful dissents, protecting individual liberty, there ruling Justice Scalia with Justice Stevens that it was impermissible to hold an American citizen in long-term military detention. And I thought that was an important opinion of his. When I gave a talk once about Justice Scalia, I identified that as one of his most important opinions and a very powerful opinion. On the Kieran opinion itself, it also dealt with many who were not American citizens, but you're right, there's an American citizen involved. The court, you're right, also, of course, you've studied this as much as anyone, but the court did resolve the case very quickly. And the opinion, I've spent many an hour trying to decipher certain paragraphs of that opinion for cases I've had. It's not easy. I will say the court, to its credit, give a little credit, did have an 8-hour or something oral argument. The Attorney General of the United States argued Kieran personally, and I've read the transcript of that to try to figure out what was going on in the opinion that did not unlock the box completely for me on what was going on in the Kieran opinion. But your point, Justice Scalia did say was not the court's finest hour. It was a rush. It was a rush. And rushes, sometimes the court has to rush, but rush decisions in a judicial context sometimes aren't always the best.
On that point, would you be open to the idea of bringing back the era of the 8-hour oral argument? I mean,
yeah,
fun.
yeah, the 8-hour oral argument. We did have one in an in-bank case maybe 2 years ago that went all afternoon. After we got back to the conference room, I don't think anyone was saying we should do that in every case.
Understood. Let's talk about judicial philosophy for a minute. I'd like to discuss Federalist 78. In Federalist 78, Hamilton discusses the dichotomy between will on the one hand and judgment on the other. Will being something that is exercised by the political branches, primarily by the Congress, by the legislative branch, and judgment being something exercised by the judicial branch. What's the difference between those two?
The judicial branch is deciding cases or controversies according to law. The legislative branch is making the policy, exercising the will. The judicial branch can never exercise the policy-making role that is reserved to the Congress. Now, admittedly, that's speaking at a level of generality, and there are tough cases at the margins always on trying to figure out what the line is here. But as a general proposition, it's important for every judge to go in with the mindset of, I'm not the policymaker, I'm the law interpreter, the law applier in a particular case. And I think that's a very important part of the Federalist Papers that's woven into the constitutional structure, into Article 3, and that judges, I certainly have tried for 12 years as a judge on the D.C. Circuit to incorporate that basic foundational principle into how I approach each case. And it is a very critical bedrock principle of what judges do in our constitutional system.
Now, within that framework, when we enact a law, what determines what it is that you have to interpret it, or that you have to interpret? Is it what we say, or is it what we subjectively intended?
It is what is written in the text of the statute, Senator. Justice Kagan said it well at a talk 2 years ago, maybe 3, at Harvard Law School. I was present in the audience. She said, we're all textualists now. She was talking about Justice Scalia, who, of course, brought about significant change in the focus of all federal judges. I've seen it across the supposed philosophical spectrum. All federal judges pay very close attention to the text of the statute. And that's why I think Justice Kagan said we're all textualists now, because she explained that every judge really cares about the words that are passed by Congress. Now, why is that? I think about it both from a formal and a functionalist perspective. As a formal matter, the law passed by Congress is the binding law, as it is what is signed by the president. It's what's gone through the Senate and the House, and that is the law. But also as a practical or functional matter, I think, having seen the legislative process, I know how compromises come together in the House and the Senate, within the House. There's negotiations late at night over precise words and compromises inevitably. Legislation is compromised. The Constitution was a compromise. Legislation is a compromise. And when we depart from the words that are specified in the text of the statute, we're potentially upsetting the compromise that you all carefully negotiated in the legislative negotiations that you might have had with each other. And so that's a danger that I try to point out when we're having oral argument in a case or we're deciding cases, that if we deviate from what Congress wrote, we're potentially upsetting this careful compromise, even if we think we would have struck the compromise in a different place as judges. That's not really our role. So I think both as a formal and functional matter, it's important to stick to the text. There are canons of interpretation which occasionally cause you a presumption of mens rea, presumption against extraterritoriality and the like, that cause you to superimpose a presumption on the text. But otherwise, sticking to what you passed is very important.
But you certainly consider yourself a textualist, and if you follow Justice Kagan's statement, we're all textualists now. That's what judging is.
Judging is paying attention to the text, in statutory cases, paying attention to the text of the statute, informed by those canons of construction such as presumption against extraterritoriality, presumption of mens rea, presumption against implied repeals, things like that are settled canons, although some of the canons are not so settled, which is a whole separate half hour of discussions.
How does textualism relate to or differ from originalism?
So originalism, as I see it, has to my mind, means, in essence, constitutional textualism, meaning the original public meaning of the constitutional text. Now, the originalism, it's very careful when you talk about originalism to understand that people are hearing different things sometimes. So Justice Kagan, again, at her confirmation hearing, said we're all originalists now, which was her comment. By that, she meant the precise text of the Constitution matters, and by that, the original public meaning, of course, informed by history and tradition and precedent, those matter as well. There's a different conception that some people used to have of originalism, which was an original intent. In other words, what did some people subjectively intend the text to mean, and that has fallen out of the analysis because, for example, let's just take the 14th Amendment Equal Protection Clause. Well, it says right in the text, equal protection. Equal means equal. As the Supreme Court said in Strouder, what is that but the law shall be the same for the black and the white? That's Brown v. Board, focuses on the text. But there were some racist members of Congress involved in the who didn't think it should apply in that way to certain least aspects of public life. But we don't, if you're paying attention to the text, you don't take account of those subjective intentions, and nor is it proper as a general proposition to take account of the subjective intentions. They can be evidence in certain cases, the First Amendment, for example, of the meaning of the words.
Of the original public meaning.
They can be of the original public meanings. They can be evidence of that, but you don't follow the subjective intention. So the original public meaning, originalism, what I've referred to as constitutional textualism, what Senator Cruz yesterday, I think, referred to as constitutionalism or constitutionalist. I think those are all referring to the same things, which is the words of the Constitution matter. Of course, as I've said repeatedly, you also look at historical the history, you look at the tradition. Federalist 37 tells us to look at the liquidation of the meeting by historical practice over time. And then you look at precedent, which is woven into Article 3, as I said in Federalist 78. But start with the words, as Justice Kagan said, we're all originalists now in that respect of paying at least some attention to, or more than some, paying attention to the words of the Constitution.
So if we stipulate for our purposes today, as we're having this conversation, that originalism refers to basically textualism applied in the constitutional sphere with an eye toward identifying the original public meaning of the constitutional text at issue, you're an originalist.
That's correct, and Justice Kagan, as Justice Kagan said, I think that's what she meant. We're all originalists now, and I think she said what she meant and meant what she said when she said that.
What, by the way, would be the argument against that? To me, that sounds like judging. What would one argue against being that type of judge, against being a textualist originalist?
Well, there are different philosophies of what a judge does, but I think the judges, what the role of a judge is. But I think the law, Article 6 of the Constitution says, this Constitution shall be the supreme law of the land. And the word law is very important there. It's not a set of aspirational principles. It's law that can be applied in court. And what is the law? The law are the words that were ratified by the people, and therefore can be applied in the courts of the United States. And it says the supreme law. What does it mean by that? It means when you pass a statute that is inconsistent with the Constitution, the supreme law controls, namely the Constitution controls over a contrary statute. And that's, of course, also discussed in Federalist 78 as well, of what's the supreme law of the land, and the Constitution's the supreme law. Again, precedent, historical practice subsequent to the passing of the text. We see that, for example, in Establishment Clause cases. The court will often look the text, what's the historical practice, and precedent, which I've said is rooted in Article 3. Those things all go into it, but the words, the original public meaning, are an important part of constitutional interpretation, and has been, I think, throughout.
Let's suppose Congress, in its infinite wisdom, with its approval rating that ranges between 9 and 11%, making us slightly less popular than Raul Castro in America and slightly more popular than the influenza virus, which is rapidly gaining on us. What if we decided that, we're all busy, there are parades to attend, there are political rallies to organize, that we get tired of the busy, drudgerous work of actually making laws, and we also don't want to make ourselves accountable for the laws we pass. It's much easier to just pass a broader statement. So we say, we hereby pass a law that says we in the United States of America shall have good law, and we hereby delegate to the herewith created United States Commission on the Creation of Good Laws the power to promulgate and interpret and enforce good laws in the United States. What constitutional issues do you see there?
Senator, the Congress is, of course, assigned the legislative power in Article 1 of the Constitution. So if it delegates wholesale the constitutional power to another body, then that naturally poses a question of whether the body exercising that power ultimately has improperly exercised the legislative power, and whether that rule or what have you that is enacted by that body is lawful because it was not enacted by Congress. So the framers intended that Congress would enact the laws, and that the executive would enforce the laws, and that the judiciary would, of course, resolve cases and controversies arising under those laws.
And yet, in some respects, it's not that far removed from some of what we do today. We may not pass something as extreme as what I've described in my hypothetical, but in some cases we will essentially say we shall have good law in area X, and we hereby give Commission Y the power to make and enforce good laws in that area. So is there some point at which we cross a threshold of unconstitutional delegation?
Well, the Supreme Court, as you know, Senator, has a non-delegation principle, and at least under current precedent, it has allowed the delegation, and I don't want to get too specific here, but it has allowed some delegation. Now, some justices or judges would say, actually, when the executive enacts rules pursuant to those delegations, that's the exercise of executive power, but I think there's been some pushback on that, and in any event, the Supreme Court has a doctrine on the non-delegation principle, and the line is debated on where that should be drawn, but there is precedent that does suggest that at some point Congress can go too far in how much power it delegates to an executive or independent agency.
And when we do that, at some point, we're shirking our own responsibility because we're making lawmakers rather than laws. And we're also consolidating into one body the power to make and enforce laws, which is not only something that can lead to tyranny, it's the very definition of tyranny itself. I want to get to the campaign finance discussion that you were having a few minutes ago with Senator Whitehouse. With regard to Citizens United, didn't the Supreme Court uphold the disclosure requirements at issue in Citizens United?
It did. I believe that was an 8-to-1 margin.
And in fact, you've written on this, that there is a distinction for First Amendment purposes, for constitutional purposes, between laws mandating disclosure and laws banning the doing or the saying of something. Isn't that right?
That is what the Supreme Court has said in certain contexts, and that is the law as set forth by the Supreme Court. Citizens United is a good example of that, Senator.
And in a case called Emily's List versus FEC, you wrote that disclosure requirements trigger a rights that receive, quote, less First Amendment protection, close quote, than speech prohibitions, other types of speech prohibitions.
And I think that followed from and is Supreme Court law and is consistent, I believe, with subsequent Supreme Court law. Of course, the subsequent Supreme Court law controls.
Okay. Do you have a favorite among the Federalist Papers?
I have
I'm not asking you to choose here between Eliza.
Yeah, no, that's right. Yeah. Yes. So I like a lot of Federalist Papers. Federalist 78, of course, the independent judiciary, the role of the judiciary. Federalist 69, which says the presidency is not a monarchy, is very important when Hamilton explains all the ways in which the presidency is not a monarchy on our constitutional system. I think that's very important. Federalist 10, which talks about factions in America and explains that having the separation of powers and the federalism system dividing power in so many different ways would help prevent a faction from gaining control of all the power for the people of the United States. And that makes it frustrating at times because it's hard to pass new legislation, but that division of power helps protect individual liberty. I think that comes a bit from Federalist 10. Federalist 37 and 39 talk about, on the one hand, how we were just talking, laws that are the Constitution over time can be, the term, liquidated by historical practice. What does that mean? That means that as the branches fill out the meaning of the Constitution over time with practices, those can be relevant in how the court subsequently interprets certain provisions. We see that in Dames and Moore versus Regan, for example. We talk also about the national and federal government. So the combination in 39, the combination that we have, this odd, that's the genius, right, of having a national government plus state governments, and then within the national government, the House is proportional representation, the Senate is state representation. That interesting compromise, which Madison, by the way, was opposed to, but that compromise at the convention. Federalist 47, which Senator Klobuchar mentioned yesterday, the accumulation of all power in one body is the very definition of tyranny. I start my separation of powers class every year with that exact quote that you read yesterday, Senator Klobuchar, because that's very important. 51, if men were angels, we don't we wouldn't need government. So sorry, I've got like 8 kids.
It's brilliant, and I think that's a great greatest hits list. If these were on Spotify, I'd say you put together a list of those. Let's close in the minute and a half I've got left. I gave myself an additional 30 seconds because of the 2 interruptions there. Tell me how you were informed by Federalist 51 and how that relates to your role as a jurist. Your role as a jurist now on the D.C. Circuit, the role that you would play if you were confirmed to the United States Supreme Court. This understanding that government is an exercise in understanding human nature. If we were angels, we wouldn't need government. And if we had access to angels to govern over us, we wouldn't need all these rules, these cumbersome rules that make government so inefficient and so frustrating. Why is that important, and how does that affect you as a judge when trying to interpret the Constitution and trying to interpret acts taken pursuant thereto?
That's an interesting question, Senator. I think we recognize that we're all imperfect. First of all of us as humans are imperfect, and that includes judges, and that includes legislators, and includes all of us are imperfect. And so we recognize that in how we go about setting up our government. If there were some perfect group of people, we'd put all the power in that one body. But because we're imperfect, putting all the power in that one body would be, as Senator Klobuchar was saying, the definition of tyranny. So I think the way we deal with the imperfection while also having a government, because we're imperfect, is dividing the power, separating the power. And that, again, to my mind, that all reinforces why the framers, the genius, despite the flaws in the Constitution, and there were flaws, the genius of separating the legislative, executive, and judicial powers, tilting toward liberty in all those respects, and then having a federalism system where we still have state governments that can further protect liberty and be laboratories of democracy as well. I think all that is because we're imperfect and because we recognize the imperfections. It's also why we have things like a jury system. Even with judiciary, we didn't trust a judge to do trials on his or her own criminal trials, or civil trials. We have a jury system to recognize, and we have usually 12, and that is designed to recognize that we're imperfect, and sometimes that's why we have group decision making. That's why we have 535 legislators. That's why we have 9 justices. We don't usually have one person, and so too in juries. So I think that all maybe stems from the same philosophical understanding that we're imperfect beings and that we divide power and that we make sure that no one person in a jury situation or other situations where our liberty can be affected is exercising total control.
Great. Thank you very much, Judge. My time has expired. I am not the chairman of this committee, even though I'm playing him on TV. I understand that under the previous order entered before he left, we're supposed to take a 10-minute break. We will stand in recess for 10 minutes.
And the Kavanaugh confirmation hearing just broke for recess. We will have much more on this after a quick break. We'll be right back. Hello, everyone. I'm Tanya Rivero. The Kavanaugh hearing is in recess, but we want to turn you to another event happening right now on Capitol Hill. Twitter CEO Jack Dorsey faces his second hearing. This time he's appearing before the House Energy and Commerce Committee. His platform has been accused of censoring conservative voices. Let's listen in.
8 to 10 million accounts per month, is that right?
Per week.
Per week?
And to thwart over 500,000 accounts from logging in every single day.
Can Twitter keep up?
We intend to keep up.
I mean, if they're using automated accounts, don't we reach a point where they have the ability to overwhelm content on Twitter and affect your algorithms?
Maybe. I mean, it is definitely, others have described this as an arms race, but I believe it's very much like security. There's no perfect endpoint. When you build a lock, someone else will figure out how to break it. And therefore, you can't try to design and optimize for the perfect lock. You always have to build a safer system.
Can't you identify the bots at least as they sign up some way so that folks understand, okay, that's a fake automated account?
In certain cases, we can, and it's a great point, especially through our API. There are more sophisticated ways of automation that actually script our site and our app that are much harder to detect because they're intending to look like human behavior with the slowness of human behavior rather than the speed of through an API. So it's a little bit more complicated. It's not a challenge we're not intending to face. We're taking it head on.
You have some creative minds. I would think you can put all of those creative minds, all of your expertise to work to do that. I want to ask you a little bit about privacy. Twitter and other companies collect information on users and non-users, oftentimes without their knowledge. Twitter's business model is based on advertising, and you serve targeted advertising to users based on vast amounts of data that you collect, which raises consumer privacy concerns. Up until last year, the privacy policy included a promise to support do not track, but then you changed your mind. Why? Why shouldn't it be up to consumers? Why shouldn't it be the consumer's choice on tracking?
Well, we do allow consumers within the app to turn off tracking across the web.
But they cannot. You're still able to build a profile on each and every user. Isn't that correct?
If they log into the account, then yes, and we allow them to turn that off.
But I understand that even when they go and they change, they opt out, but you're still collecting data on them. You're still tracking them.
I don't believe that's the case, but happy to follow up with you with our team.
Okay, let's do that because I'm out of time. Thank you.
Chair now recognizes the chairman of the Republican Conference, gentlelady from Washington State, Kathy Morris Rogers, for 4 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Dorsey, for joining us today. I want to start off by saying that I think Twitter is a valuable tool in modern communication, and it's why back in 2011 I was spearheading an effort to get our members signed up and using this tool. I think it's a great way to interact with the people that we represent, and since then it's been amazing to see the growth of Twitter and the Twitter users all across America and the world. It's why I think this hearing is so timely. There's a lot of serious questions that Americans have regarding tech platforms and the ones that they're using every day, and the issues like data privacy, community standards, and censorship. Today, I want to focus on Twitter's